Welcome to Come Back with a Warrant.
Welcome back to Come Back with a Warrant with attorney Michael Gottlieb. The American legal system is built on a simple premise. You are innocent until proven guilty. But in the courtrooms of South Florida, that premise is challenged every single day. For 3 decades, Michael has stood between the state and the accused, litigating over 150 jury trials in state and federal courts. From the Florida legislature to Broward County defense bars, his work is centered on a single mission: protecting the constitutional rights that keep us free. Michael, thank you so much for joining me today.
Always a pleasure.
Michael, before a case ever gets to trial, what are the earliest signs that the prosecution's case is weaker than it looks on paper?
Well, I never really want to think that the prosecution's case is weaker than it looks on paper. So I always overestimate, right? I always take my worst case scenario because I think the best way for us to build a case is to overestimate what they're going to do. So one of the ways that we always work up a case is take the state's best position and then build our defense towards that position. So that's always hard to estimate. And then when we start to see it fall apart, right? Because I'll bring my client in, I'll cross-examine them, put them on for, a straightforward testimony from them, and then cross-examine them. My partner will do the same thing. So they get 2 different kinds of lawyers testing the evidence. And the 2 of us, if you ever sat here while we talked about a case, it's like an old married couple bickering over the facts. We see things differently, but that's really what gets us to the best position to try to figure out a weakness on the state's case. But we always look at the case as if it's going to proceed, and then we attack it and try to find its weaknesses.
And then how much of a case really comes down to the quality of the evidence and what tends to make evidence unreliable or maybe vulnerable?
So when we pick a jury, we always tell the jury, where does reasonable doubt come from? Reasonable doubt comes from 3 places: the evidence, a lack of evidence, or a conflict in the evidence. So to answer that question, we really need to get into what is the evidence. There's direct evidence, right? A witness who saw somebody do an act. That person comes forward and testifies. There's circumstantial evidence. I didn't see him commit the act, but I did see him running nearby, right? So, obviously the first is better than the second from the state's perspective, but just because a person says they saw something, did they really see it? I've had witnesses in the middle of a murder case testify my client's the person who committed the crime, and then through cross-examination proved they weren't there, they heard about it, they heard what he looked like, and testified to the police, and the police had no idea that the person was giving false testimony. So, you really have to test the evidence. The evidence itself can rise to, because it doesn't prove what the state believes it's going to prove, reasonable doubt. Then you can have conflicts in the evidence. So you have 2 people. Let's say we're talking about the color of a car. One says the car that left the scene was red. The other says the car that left the scene was blue. That's a conflict in the evidence. If they arrested me in a blue car or a white car, that's a conflict that suggests a reasonable doubt. So you have evidence, conflicts, or you have a lack of evidence. Let's say you have a case with a gruesome murder scene, blood everywhere, but there's no DNA from the person who they claim committed the crime. There's not a fingerprint. There's not a hair sample. There's nothing left by the person that suggests they committed a crime. And in fact, maybe they were across town, so you don't even have their phone pinging off a cell phone tower, but you've got people who claim that they committed the crime. That would be a lack of evidence. Those are the 3 most common areas that cause reasonable doubt for the state in the presentation of their case.
And then how often do problems come from how the investigation was handled rather than what they actually found?
So very often. In fact, for years, I've taught at the police academy and taught law enforcement officers really how to properly document. And we see mistakes all the time. I see police reports that are cut and paste jobs. So the police officer is literally using the same police report over and over again and cutting and pasting different facts. That's a major problem. We see officers who put he for she. Okay. A common, maybe a Scrivener's error, but it could mean a lot in the end, and I'm not trying to fault law enforcement. They've got difficult jobs, but at the same point in time, if they haven't documented their file, if they haven't reviewed their file, I'm going to review their file 50 to 100 times before we go to trial. I'm going to know every I, every T, right? Better than they are, because they wrote it and then they moved on to the next case, whereas I've lived with that case for 3 to 5 years. If I'm going to trial, I've read everything over 5, 6, 7 times. We're going to find the mistakes they made, including mistakes that officers make in the investigation. I've had officers in a DUI manslaughter document the case as being a three lane road when it's 4 lanes. Well, that makes a major difference to how the evidence was spread across the road. I've had an officer document 2 impacts with a metal rail guardrail at the side of the road, and there were 2 impacts, but by the time they came to the final report, they only documented it as 1 impact. All that changes the speed calculus in the case. And when you bring those out, I've actually had an officer on the witness stand admit, yeah, I made a mistake in my final report, blew everything up, and got a not guilty on that DUI manslaughter charge at trial.
So, Michael, when it comes to witnesses, what are the biggest issues that can start to break the case apart with them?
So, witnesses always have a bias, interest, and motive. I don't care what anybody says, right? They always have a bias, interest, and motive in how the case turns out, even if they're completely unrelated. Their interest is, this is what I said day one, this is what I saw, and I'm sticking to my guns, right? And many people, they don't want to be cross-examined, and so you can always go after a witness and show that they have an interest in the case. Now, it might not be that they're the victim, they have a very different interest than the victim, but nobody wants to feel that their credibility has been diminished. So, attacking a witness's credibility, whether they were in a place to see it, how far they were, did they have their glasses on, was it day or night? If they get one piece of evidence wrong, just one piece of evidence wrong, you can chip away at all their credibility. Because if you can show they got one wrong and you're able to get them to admit that, then maybe they got others wrong that they're unwilling to admit, because everybody wants to feel secure in their opinion. And if you can start to get somebody to feel insecure about their opinion, then you have diminished the credibility of the witness, even though they don't have any stake in how the case resolves, and you can get a not guilty simply by diminishing the credibility of that witness.
I want you to take me back to the beginning. When you're reviewing a case, what are the first things that you look for that tell you it may not hold up?
So we always look to whether or not there's probable cause, right? Is it more likely than not that my client committed the crime? And I think of every case sort of as a circle, right? So there has to be enough data points in order so that you can connect those dots to make that circle, right? And so, if you start to get through your case and all of a sudden, you're kind of falling apart, well, then that doesn't make sense. So we always look to see, and if you think about it in terms of the elements, right? So I had talked in a previous episode with you about the elements of the crime. If there's 5 elements and you're starting to connect them, and elements 3 and 4, are kind of grainy, they're kind of obtuse in terms of the evidence, you might get close there, maybe circumstantially, but that's what you start to look at. If they can't connect the dots, then I know I've got a client who's not guilty or going to get a not guilty verdict at trial.
And then when does a weakness in the case become something that you can actually use to challenge the charges?
I think from day one, right? So we always try to exploit, we go to many bond hearings, which are 10 to 12 hours post arrest, meaning client gets arrested 8 o'clock at night, they've got a bond hearing 8 or 9 o'clock in the morning. We always review the probable cause affidavit, and I'll try to find even the smallest detail to show the judge, look, I agree there's probably probable cause here, but this factor really diminishes the witness's credibility or how the officer saw this. And so even at a bond hearing, I'll argue that if the state's asking for a $10,000 bond, I may ask for a $5,000 bond or a release on their own recognizance, because from the outset, there's a problem with the case. And I'm going to take that minutia, that small problem, I'm going to blow it up in front of the judge, right? And try to explain to the judge why this is a huge problem for the case. It's day one. If I'm finding just this small problem now, can you imagine how big it's going to be at the end of the case? To try to convince the judge there isn't probable cause. It's not more likely than not that my client committed the crime, and therefore you should give that client a smaller bond.
I want to talk about the prosecution's side. What happens when the prosecution realizes parts of their case aren't as strong as they need to be?
The prosecution's often in a difficult position because the prosecutor handling the case, let's think of it as a plane. They're just flying the plane. They're not the ones who built it. So they've got to answer to other people in their office and to supervisors and to victims, right? So the victims, the witnesses, the police officers all sort of built it. The prosecutor's just flying it. If they realize this thing's not going to fly, they oftentimes don't have the discretion to simply drop the case. So my job becomes that much harder because then I've got to convince a supervisor. And maybe the supervisor says, well, our victims are really adamant about this case and about what they saw. We see and hear what you're saying, but we've got to answer to them. And sometimes I've been forced to go to trial simply because the victims were so adamant that the case should proceed to trial and that their version was correct, that the prosecutor says, look, we're going to let a jury decide. And so it's really difficult. I think they have a very difficult job, and I know that my job is much more difficult trying to convince them to do what I believe is the right thing, but their hands are often tied.
We've covered the pressures of the defense, pressures of the prosecutor. How does the pressure on witnesses, investigators, and even the defendant affect how strong the case appears?
So let me start with the defendant. The defendant from day one, accused of a crime many times, put on a website, embarrassed, ashamed. From day one, they're getting punished, whether they're guilty or not, right? Very often, people are wrongfully arrested. Very often, people are arrested and charged with a crime that's far more serious than anything that they've committed. So the pressure on a defendant is tremendous. They're also facing the loss of liberty, and we don't take that lightly. I know that if I don't do my job the right way, this client could be going to jail for a very long time or prison for a very long time. So I think, when we're dealing with a defendant, they have the highest burden of anxiety, stress, depression on their shoulders. Anytime you have a victim on a case, the victim's going to have a similar position. If they truly have been victimized, whether money was stolen out of their bank account or they faced somebody face to face in a robbery, they're also going to have anxiety about coming to court. I've had witnesses that couldn't even get into the elevator in the courthouse. They just had so much fear, so much anxiety, so much trepidation that we had to do special accommodations and take their depositions in places outside the courthouse. So I think they also carry a very heavy burden. Sometimes witnesses and investigators have the same thing, because if I witnessed something and I saw somebody do something wrong, I want to go to court and help prove that. And if I feel like, and everybody doesn't like lawyers, and that lawyer's going to come after me, and that lawyer's going to diminish my credibility, and that lawyer's really going to make me look like a fool, I've got anxiety over that, right? And of course, law enforcement officers feel the same way, many of them, about attorneys. That the lawyer's going to come after me, is going to make me look like an idiot or a fool or a liar or whatever. And so they get anxious too. The biggest problem with officers is many of them fail to prepare before going into a hearing, a deposition, or a trial. And that's when we're going to catch them with their pants down.
I have to add something. I had jury duty last month in Florida, and boy, was I anxious. I didn't get called to be a juror, but I understand when you're saying just walking into the courthouse and going through these proceedings, there's so many intimidating factors. And I do this for a living. So I can't imagine how some of these folks are feeling. Thank you for pulling that together and really helping us to tune into what they might be experiencing. Here's where I want to wrap up today, Michael. When you step back, and you look at everything together, what separates a case that holds up from one that actually starts to fall apart before trial?
You know, many cases don't fall apart before trial. Many cases fall apart in trial, right? So, one of the things that we've done here for many years is we've been forced to try cases. Plea offers life in prison. Okay. You have no choice. You're going to trial. And then, I've been able to win those cases where the plea offer has just been, in my opinion, completely unreasonable. I take that case to trial and you get a not guilty. So sometimes you're looking at that case. I remember one armed robbery, armed burglary. I had a fight with the client on a Friday. He was cursing me out, telling me I'm the worst lawyer ever because I was trying to tell him, I don't know that I'm going to beat your case. You should resolve this. Two of his co-defendants were testifying against him that he was one of the four people that went into this Eckerd's Drugs. It was a long time ago and committed this armed burglary, armed robbery. We went to trial, and at the conclusion of the case, the judge said to me, Mr. Gottlieb, you methodically eviscerated the state's witnesses, and I got a not guilty verdict. So you never really know until your feet are to the fire.
Well said. Thank you so much for your insights today. Another terrific podcast. Folks, that's it for today's episode of Come Back with a Warrant. For more resources, notable case results, or to schedule a consultation regarding your specific situation, visit browardcriminallawyers.com or call Michael directly at 954-682-0999. Thank you so much for listening, and please remember to like, leave a review, and subscribe to the show. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.